Sure. I'm Randy Barnett. I'm the Carmack Waterhouse Professor of Legal Theory at the Georgetown University Law Center, where I also direct the Georgetown Center for the Constitution. Sure. Well, I went to Harvard Law School after being a philosophy major at Northwestern, and after law school became a criminal lawyer as a prosecutor for the Cook County State's Attorney's Office, and it's what I went to law school to become. I went to law school to be a criminal lawyer after watching the television show The Defenders with E.G. Marshall, and ended up on the prosecution side rather than the defense side, and considered myself as a lawyer to be a trial lawyer, someone who could argue jury trials, and then I went into teaching a little over 30 years ago. Yeah, I mean, the prosecutor's obligation is to do justice, which means that if you believe somebody is not guilty, you're not supposed to prosecute them. And I was there in law enforcement to see that the bad guys went to jail and that the good guys didn't. So that was what drew me there, as well as kind of the general excitement of doing trial work. When I was a philosophy major at Northwestern, I actually toyed with the idea of being a philosophy professor. But then, thinking about it for a while longer, I went back to Plan A and to be a lawyer. But when I was in law school, I kind of realized that as a law professor, I could write about the very sorts of things I was interested in doing as a philosophy professor, and so maybe one day I'd be a law professor. I just didn't really have a real clue as to how hard it was to get a job as a law professor and how competitive that was. Yeah, well, actually, the answer to that is pretty simple, and it unifies all of my work, and that is an interest in justice in general and liberty in particular. So those are the themes that have always driven my career. I wanted to become a lawyer. The reason why The Defenders as a TV show turned me on is because I could see that lawyers it was a job dealing with justice. And when I got to college, I discovered philosophy, which I had really never heard of as a high school student. And I discovered that for thousands of years, people have been writing about justice. So that's really what's always motivated everything that I've done as an adult. And basically, there's a difference between doing justice retail as a lawyer, case by case, and trying to effectuate a more just society wholesale by writing about it and hoping that what you have to say about it would actually affect the system as a whole. Maybe the easiest way to sum up how what I do fits together is based on my first book, which is called The Structure of Liberty, Justice, and the Rule of Law. That lays out in general what I think justice is, and in particular that means the enforcement of particular individual rights that I defend in that book, as well as the rule of law, and why both are important. And from there, if you look at my constitutional law scholarship, it's how a written constitution enforced according to its original meaning can be a means to the end of protecting the individual liberty and rights of the people. And so that's the way the two things sort of fit together. No, I mean, a written constitution itself is not essential, but a written constitution is useful, and it's useful to provide the law that governs those who govern us, to keep those who are responsible for law enforcement themselves subject to the law. And that means that putting it in writing helps effectuate that. And it also means that the people who are subject to that law, which are the government themselves, are not the people who ought to be able to change it. So they can't change it. In order to change the law, so the courts can't change it. They're not supposed to be able to change it. Law enforcement should not be able to change it any more than we can change the traffic laws that we are governed by ourselves. We have to go through the legislative process, and they have to go through the amendment process. So essentially, all that the original meaning approach to constitutional interpretation means is that the meaning of the Constitution has to stay the same until it's properly changed, and the way you properly change it is with the amendment process. Right. Well, I consider myself first and foremost a legal scholar, and I've never really considered myself either a litigator or a legal advocate per se. I got drawn into litigation on the basis of my scholarship. Back in the day when the medical marijuana movement was going on in California, there was a lawsuit on behalf of the against the Oakland Cannabis Buyers Cooperative, or OCBC, and the trial judge in that case, Charles Breyer, who's Justice Breyer's brother, asked the parties to brief the Ninth Amendment, which says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And so the lawyers in that case in California went around the country trying to find somebody who knew something about the Ninth Amendment, and that was one of my particular expertise. And so they came to me, and I helped them write a few pages of their trial brief, and gradually got drawn into that lawsuit, which was a Commerce Clause lawsuit. And that's how one thing led to another. The OCBC case led to the Raich case, which we brought so that we'd have better facts to make a Commerce Clause challenge. And then all of that experience fed into my scholarship on the original meaning of the Commerce Clause and my book, Restoring the Lost Constitution, which came out right about the same time the Raich case was argued. And then after a hiatus, in which I thought that Congress would never be able to find a law that would violate or exceed its Commerce Clause powers as interpreted by Raich, Congress managed to do that in the Affordable Care Act case. And so a body of knowledge I developed on the Commerce Clause turned out to be highly relevant to challenging that law. And then that's what's taken me up until today. Well, I think early on I signed a couple, and I've since become convinced by things I've read that it's really irresponsible to sign a brief unless you consider yourself a real expert on that subject, so that you have an independent opinion on the merits of the argument being made in that brief, other than the fact, well, it sounds good to me. And I think most law professors, unfortunately, sign on to briefs because they sound good to them, but that doesn't necessarily mean that they really know the field. So I really refrain from signing amicus briefs that I'm not expert on, and usually that I haven't really worked on a lot. I've done quite a few amicus briefs with the Cato Institute, and those amicus briefs are rather hands-on. I'm working with other lawyers, but I'm actually quite involved in the crafting of those briefs. And I've also, the same thing is true with the Constitution Accountability Center. So I tend to agree with the justice about law professors just signing on. It's essentially like signing a petition saying, I like this side. And unfortunately, it's not really their expertise that's being brought to bear. It's greatly improved my teaching because it's forced me to approach teaching from a litigation standpoint that I never really had before. Just as an academic dealing with theory and ideas, I now can expressly teach constitutional law the way I used to teach criminal law, and that is as a former litigator in the field. I could tell the students, well, this is what you need to know, and this is what you don't need to know, and this is how the system works. And I can now do that in constitutional law that I couldn't when I couldn't do it before. But this actually is not inconsistent with the way I teach constitutional law. Unlike a lot of con law professors who go into class and get a discussion essentially going on whether you like this side or whether you like that side, and if you like this side, what arguments can you make for it, and if you like that side, what arguments can you make for it, I don't teach constitutional law that way at all. The way I teach it, and I have a case book that is organized this way, I teach the narratives that sort of each side of whatever constitutional culture we're in believe in, because most of the participants, in fact all the participants in the legal system sort of buy into one of these narratives or the other. And these narratives have developed over centuries in front of a court that's been in continuous existence for a couple centuries. And my job, I think, is to teach the students what these narratives are. I think other professors end up teaching it, but they don't. But they're doing it by studying doctrine after doctrine. And I think it's a lot easier just to say, "Hey, look, let's start at the beginning. This is what's developed, and this is how this justice this is the narrative that this side of the court is imagining in their head that they're participating in, and this is the narrative of that side." And essentially, there's an internal logic of each side's views, the conservative side at any given time and the progressive or liberal side at any given time, and I try to teach that logic. And that puts me somewhat outside the material that I'm teaching. I, by the way, disagree with both of these worldviews that I'm teaching. So it makes me a critic, but of both, and not really an advocate, so to speak, of any particular outcome in any particular case. Yeah, well, the reason why my chair is titled legal theory, or rather, let's say constitutional law, is I'm a contracts professor and a contract scholar. I have a contracts casebook, and I've done contract law theory since before I did constitutional law theory. And what legal theory really is, it's basically thinking about the doctrines in a systematic way, and it's also normative. It can be normative, and in this case it is normative, and that is arguing, again, with justice in mind, what ought the doctrine be? What ought the courts be doing in order to see that justice is done? And that's the kind of thing that practitioners generally don't really have time. It's not really part of their job, and they really don't have time to think about systematically. And I certainly didn't when I was a criminal prosecutor. But as a law professor, I think that's my job, is to figure out what ought to be done, what ought to be the case, and make sound arguments for why that's the case. I mean, in a sense, it makes me an advocate. I mean, I'm an advocate in that sense. I advocate the views I do about justice. I advocate the views I do about liberty. Politically, I'm a libertarian. I'm known to be a libertarian. I advocate that. So it's not like I don't advocate things. But on the other hand, I'm not an advocate in the sense that I'm on this side of a particular case or that side of a particular case on a constant basis.